amending it, my lord, I am not in a position to file my power. So easy.
If you want that to be them to amend it and introduce.
Please, my lord.
You want them to amend the memo of parties.
Yes, my lord. They'll have to amend that, and thereafterwards I can secure instructions and then file my power also to them. In the meantime, let them be directed to serve set of papers on me.
You will appear for GBA.
Yes, my lord. GBA as well as since A2 is BBMP and A4, my lord, is the Deputy Commissioner TDR of the BBMP, earlier BBMP.
Yes.
So they'll have to amend it appropriately and then find out, I'll have to take instructions from them.
No, BBMP, of course. BDA, definitely you're there, no?
Yes, GBA, I'm definitely there.
Also, BBMP is also there.
So BBMP, my lord, is ceased to exist. In view of that, my lord, they'll have to array the concerned corporation where the particular subject matter falls. Because that is the recommending authority.
Senate Council appearing for the complainant seeks time to amend the memo of parties.
Please, my lord, I appear for A3 in serial number 7 to 11, my lord.
Let the same be amended within a period. Let the amended memo of parties be filed within a period 2 weeks from date.
Please.
Sir, 25th September.
6 to 11.
7 to
7 to 11.
7 to,
Please.
7 to 11. 12 urgent. Serial number 13.
For complainant, my lord, in this case, my lord.
Ready to hand over the DDU, Lord. Accused is the husband.
Lordship, there is a arrears of around rupees.
I'm ready to hand over the DDU. Whatever the order has passed.
And
4 lakh.
this honorable court has ordered on 23/11/2024, my lord. Within a 4 weeks, they have to.
The pending amount is
It is in
4,29,760, Lord.
execution, my lord. It is in family court. When he is evaded the notice with his powers.
How much is the total amount according to you?
4,29,760, Lord.
It is arrears in before the family court, my lord.
Yes?
Arrears before the family court, 4,29,760, my lord.
Yes.
In before this honorable court has ordered 25,000 per month, which is ordered on 23/11/2024 month. Order was within a 4 weeks he has to pay. Till now he hasn't paid anything.
Lord, from 1 year, I'm ready to hand over the DDU, Lord. 4,29,760 was order you, Lord.
The belated payment does not first the offense, my lord. He has to punishable.
4,29,760.
I'm ready to comply the order now.
You want it or no?
My lord, arrears, it has to be because
You want this or not? We'll record that statement that he's giving. Rest he'll pay.
my lord,
Rest of the amount, if any, is pay. But you take that at least.
my lord, on submission, my lord. In execution also, he is a police sub inspector. He is evaded every notice which is sent by the honorable family court, my lord. From here, honorable court has ordered within a 4 weeks he has to pay.
Yes.
From till now, he hasn't appeared before the court. He hasn't paid anything. He just previous date he said that he will pay. Up to that he doesn't appear before this court, my lord.
From last year September onwards, your Lord, I'm ready with the DDU, Lord. It's a 4th DD. I'm changing the DD. They're not receiving them.
This is to be deposited before the executing court.
No, Lord. Please, your Lord. This onward court has passed the order saying that within 4 weeks, the respondent has to deposit this amount.
This honorable court order also, my lord, which is around 23 lakhs rupees.
Let's see that order. Which one are you saying?
That's
The order, the disobedience of which you are alleging is 23rd of November 2024. That only says 4,29,000.
That is arrears of family court, my lord. Along with that order has.
For that execution case has been filed, your Lord.
In
Execution
MFA, I have filed one application for
case is
maintenance.
pending for consideration, your Lordship.
What is the date of filing that application?
My lord, along with my MFA, I have filed it, which is allowed on 23, my lord. Just a portion of the order, I will read it, my lord.
No, what is the date of the application? IA 1 of 2018.
My lord, 13/12/2018, my lord.
30?
13/12/2018. And also, my lord, I have filed an enhancement application before the family court. He
You're
hasn't
in
led his
contempt-
evidence in this.
contempt jurisdiction, so he has to pay you 25,000 per month.
Yes, my lord.
How much does that work out to?
Till now, it is 27 lakh, my lord. 23 lakh, my lord. Apart from execution.
Your Lordship. Execution, some of the amount has paid in execution court, Your Lordship. That execution
Nothing,
case,
my lord.
that
I will
execution
place
case-
before this court,
that
my lord.
execution-
They have
that
evided
execution-
every notice. They have
One
evided.
minute, let's hear it.
Please.
The execution, after receipt of some amount, Your Lord, that petition has been disposed, Your Lordship. After that, MFA has been filed, Your Lordship. In the MFA, from the date of order, Your Lordship, 4,29,000 has to pay, Your Lordship. From past 1 year.
4,29,000 one amount. There's also in addition interim maintenance of 25,000 from 13/12/2018.
That amount will comply, Your Lordship. That amount,
That is what now, if you look at it, you're talking about 7 years.
Your Lordship, one execution petition has been disposed, Your Lordship. Another execution petition is pending for consideration, Your Lordship. The amount has
Tell us how much you have to pay as per this order.
4,29,000.
This order, read the order. You have an order of 23rd of November 2024.
From past 1 year, I'm holding the DD to give it to Your Lordship. They're
All
not-
right, this DD
But they're not receiving the
as
DD.
far
Your
as
Lordship.
as far as DD is concerned, if they don't receive it, we will not proceed against you on contempt. That's all. But as far as the other matters are concerned, other amount is concerned, you have to pay.
It's going to pay. I will pay.
How much you are, according to you, have to pay?
Take instruction, I will, some amount I will pay you.
Not some amount. You tell us as per this order how much according to you is payable in accordance with the order of 23rd November 2024.
We'll exchange the memo of calculation, then I will submit.
My lord, if they have filed, if they have paid anything, it is necessary for the memo of calculation. They haven't paid any single rupees. Please,
So how much according to you?
my lord, execution petition in 254 of 24, which is pending before the family court. In that, 4,29,760 rupees is pending. Then from this honorable court, it is ordered around 25,000 per month. Till now, it is around 23 lakh. So totally, it will around 27 lakh for.
You take this DD at least. Do you want? Otherwise, if you don't want, then you.
My lord, now my concern is it.
We'll have
He
to
is a
record
law
that he's
enforcing
offering you
officer,
a-
my lord.
We'll have to record that he's offering and demand draft, and you're refusing to accept.
No, my lord. I will. Just one submission, my lord. He himself is a police sub-inspector. He's a law enforcing officer. He hasn't followed the honorable court orders till now. If he himself is doing it, what is the concern of the others, my lord?
Now, do you want it?
Please, my lord.
Give it. to-
At least it should be at least 27. It is others of 27 lakh, my lord.
Are you taking it? Are you not taking it? We are asking you this simple question. You take it or you don't take it? The learned counsel for the response for the accused is handed over a demand draft of a sum of rupees 4,29,760. The learned counsel for the complainant. Full stop. The learned counsel for the complainant. Next part. The complainant submits in addition to the said amount. The accused is to pay a sum of rupees 25,000 per month as an interim maintenance, which is from the 13/12/2018. However, no amount is being paid as yet. The suppleant counsel for the accused submits that he would make some payments before. How long do you want? How long do you want?
Lordship.
How long do you want to comply with this?
4 weeks, Your Lordship.
Within a period of 4 weeks.
I'll let them furnish a memo of calculation, whatever
So
remaining.
you take your memo of calculation, whatever according to you is payable, you pay that, and then you come. Otherwise, it's right. You can't not follow the order. This order is passed in
24/11.
this 2018 order. 24 it has been passed. Oh, you know, almost a year, 2 years of one month.
Past 1 year, I'm requesting to take the DD, Your Lordship. They are not received the DD, Your Lordship.
Their
Tell him
maintenance
you
is
have to
only
pay,
this
no?
amount.
Pay that. List on to.
30th September.
Is a DD live?
Yesterday's DD, Your Lordship.
Yesterday.
December 14th.
Lord, I appear for the complainant in this matter. Lord.
Yes.
The state had
Order
preferred a
number-
review petition. State had preferred a review petition in this matter and it's pending for, it's listed tomorrow before the roster bench.
Learned Council
It's true, Lord. It's true.
Review listed before the court tomorrow. Request for adjournment, the request list.
29th October.
Obliged, Lord.
December 15th. SB Mukkanappa.
And appears for the complaining. and
Lord, in
interest
this
of justice.
matter, the accused number 4 has complied with the order.
Others may have to require.
In fact, different departments were given directions to pay the differential GST and VAT amount. Other departments are yet to comply with the directions, my Lord.
File it,
Please.
please.
8th of October. Syllabus 16.
Accused in this matter, my lords. We have preferred an appeal, my lords, which is at 423 of 25. The office objections have been complied today, my lords. We'll move a memo tomorrow for posting, my lords.
Learned Council for the accused submits that they preferred an appeal. That accused preferred an appeal. No, that don't say it. That an appeal has been preferred against the order. The disobedience of which is alleged. Do you have the number?
423 of 25, my lord.
WA 423 of 25. Request list. Dash along with WA 423 of 2020.
2nd November.
Public.
Syllabus 17.
The council for respond number 4 and 5 have recently come on record.
Yes.
Supposed to file the counter affidavit.
Panchayat is the answering. this one.
None appears for the accused number 4 and 5. Rest of justice re-notified.
So 8th of October.
Millards, a shorter date, Millards. Considering Millards, they are trying to form layouts out of the land, Millards. There's a stay order by the learned single judge, Millards.
So 18 urgent. Syllabus 19.
I'll make compliance, my lords. Sir.
Hearing for the complainant, my lord.
My lords, I could not get it translated. I just received it, my lords. Just received it, my lords. Lords, our operative portion is at page number 10, my lords. The name of the husband has to be replaced with the name of the complainant, my lords. We have issued an endorsement that it would be carried out, my lords.
My lords, there was also a request that the site should be granted, my lord, accordingly. But the site has not been granted so far, my lord. Even the name has not been changed. The name is okay.
Let's see the operative part.
It is at page number 10, my lords.
Page number 10 is
writ petition 11365 of 2021, my lords. Operative portion at running page 10, my lords. In the second paragraph, my lords, in view of the above, the writ petition is disposed of, directing the respondent BDA to enter the name of the petitioner instead of a deceased spouse.
And then consider the claim for allotment.
Yes, please. That is
Where
also
is
in
that?
the end of, it is in the second paragraph, my lords. I may read, my lord. ಪ್ರಸ್ತುತ ಪ್ರಾಧಿಕಾರದಿಂದ ಡಾಕ್ಟರ್ ಶಿವರಾಮ್ ಕಾರಂತ್ ಬಡಾವಣೆಯಲ್ಲಿ ಸಾರ್ವಜನಿಕರಿಗೆ ನಿವೇಶನ ಹಂಚಿಕೆ ಮಾಡುವ ಸಲುವಾಗಿ ಪತ್ರಿಕಾ ಪ್ರಕಟಣೆಯನ್ನು ಹೊರಡಿಸಿ ಸಂದರ್ಭದಲ್ಲಿ ಸದರಿ ಪತ್ರಿಕಾ ಪ್ರಕಟಣೆಗೆ ಅನುಸಾರವಾಗಿ ತಾವು ನಿವೇಶನಕ್ಕಾಗಿ ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ್ದಲ್ಲಿ ತಮ್ಮ ಅರ್ಜಿಯನ್ನು ನಿಯಮಾನುಸಾರ ಪರಿಶೀಲಿಸಿ ಅಗತ್ಯ ಕ್ರಮ ಕೈಗೊಳ್ಳಲಾಗುವುದೆಂಬ ಅಂಶವನ್ನು ಹಾಗೂ ಉಲ್ಲೇಖದಲ್ಲಿ ಮೆಲಾರ್ಡ್ಸ್ there was a writ appeal that was pending, ಮೆಲಾರ್ಡ್ಸ್, which is now been disposed of, allowing the BDA to make allotments, ಮೆಲಾರ್ಡ್ಸ್. So as
You have to do two things. First, put a name in the lot.
yes, that has been carried out. ಮೆಲಾರ್ಡ್ಸ್, we will correspond with them and then tell
No,
them.
there is an order that you will change his name. Put a name.
You
don't have a copy of the order?
Changing of the name, my lords, that has been carried out, my lords. That is my instruction. Change of the name from a deceased spouse name to as that of the complainant has been carried out, my lords. As regards the allotment of
That's
the
not what
site,
your memo is saying.
sorry,
The
my lord.
memo is saying, counsel for the accused would place on record endorsement therein confirming that the name of complainant would be replaced. Instead of that of her husband, if the requisite documents are provided for further process.
In the records, my lords, meaning to say her Aadhaar card, her PAN card, all that is what we would be asking, my lords, and it has been dispatched today, my lords. I received it only now. But I have been instructed, my lords, that the name would be changed, my lords. That the name would be changed. The changes would be carried out in all the registry and.
That's not the order. The order says change a name.
Yes,
Take
please.
from the cause title of the petition and change a name. You don't require anything more. It's a direct order.
Please, I'll instruct them, my lords, to
And
change.
then you
the
second is process the allotment. Then if you require some documents, you can ask for that purpose.
Yes. If my lordship can kindly grant me 4 weeks time, my lords, because now we have been permitted to allot sites in this particular layout, my lords.
Learned counsel appearing for BDA 6. 4 weeks time to report compliance.
Acha bhai.
9th of October. Number 20.
What is sought for, my lords, is one complaint to the order at page 11. It starts at page 11. And, my lords, operative portion, my lords, will see at page 14. The
BDA, you'll have to be in here also. You're also against BDA.
item 20.
Serial number 20. BDS is,
I'll take instructions on Monday, my lords.
Learned counsel appearing for Karthikeyan, learned counsel for the BDA 6 time to take instructions. Just give him a copy, he may not be having.
I'll answer.
9th of October. Number 21.
Could there be an earlier possible date?
Yes,
Could there be any earlier possible?
won't come otherwise.
Okay.
Let it.
Number 21.
With your lordship's permission, file the compliance affidavit.
So I will go through it, Your Worship. Kindly start accommodation.
No, with respect to the direction not to interfere with the CBSE schools, I have filed in the affidavit that there is no interference with respect to the CBSE school. And the other relief with respect to the reimbursement of the RT fund, that also has been paid in 2 installments dated 11/3/26 and 25/3/26, stated at para 7 of the affidavit.
Yes.
Lordship, kindly, 2 days accommodation, Lordship.
Why he says they've already
Lordship,
paid on
yes.
25th of March and 11th of March.
Lordship, as per the annexure AJ, Lordship, representation is to consider my representation, Lordship. I have already submitted before the accused department, Lordship. That is not at
No, what if
considered
you
till
agree?
day, Lordship.
If you are aggrieved by this, they'll have.
Lordship,
You'll
kindly
have to take some
have it
steps.
on tomorrow, Lordship.
All right, have it.
Tomorrow, Lordship.
Seal number 22.
They seek for 2 days accommodation, my lords. The order is being passed through the course of the day, my lords. It will be complied, my lords. I'll file it, my lords.
Council appearing for the next week or two further days to pass to report compliance. List on put it on Friday.
31st July.
Obliged.
Seal number 23. Sir, SK Mithun, commercial.
None appears for the parties. Rest of justice re-notified.
4th of November. 24 urgent.
My lords, I appear for the appellant. I have not moved for an examination. Let's see. Respondent seems to have sought the respondent.
He said he told you.
It's a very short point, my lord.
He said he had no objection. He said you had no objection.
No. He did not inform me at all. I've been waiting from the morning.
He asked you, have you informed him? You said he has no objection.
Sorry, there is absolutely. I was here, like from the morning.
All right, you tell us. Tell us.
Please. Like the short point in this case is the entire finding or the reasoning of the trial court is that an agreement between the appellant and the respondent is invalid and unenforceable.
Yes.
As such, it is against public policy.
Yes.
The arbitrator has passed an award saying that the agreement is annulled on a different finding, that the respondent has failed to perform the obligations under the agreement.
Yes.
The trial court's only observation is that since the agreement itself is invalid, unenforceable, it is against public policy, there was no arbitrable dispute at all. Therefore, the question of going into the willingness or unwillingness or readiness or otherwise shall not arise. As such, it has set aside the award which has annulled the agreement. The entire finding is, that the agreement is invalid.
All right.
It's a short point.
What point?
That
the agreement is invalid.
Millards, I will just, take your lordship's kind attention. Your lordship may kindly turn to page number.
That is point number 2. Point number 2 is whether the agreement is invalid against public policy.
It's not valid and against public policy, which is exactly the award the arbitrator has passed. Your lordship would get the same at page number.
Let's see the reasoning.
37, Millards. Ink page 37.
Award starts at page 66. No?
Millards,
Your award starts with page 66. Is at page 66.
this is a decree, Millards. In page 66 is the decree.
Where is your award in this?
The award is at, Lordship would get it at 78 it starts,
Yes.
88 is the award. The claim petition is allowed. It is ordered that Exhibit P6, the Management Development Agreement dated so and so, stands annulled as prayed for on a different finding. But the trial court says that the agreement itself is invalid. Therefore, no license. Setting aside the findings or the reasoning of the trial court is not under challenge by both the parties. The natural consequence should be to annul the agreement.
You are not aggrieved by the award.
No.
What are you aggrieved by?
In fact, the respondent has aggrieved by the award. The award was in my favor. I filed the claim petition.
No, so why are you filing
In
this 30?
By passing an order by the trial court, it has set aside the award by holding that the award should go.
But according to you, the reasoning is that the whole agreement is against public policy.
Right.
So what difference does it make to you?
It has set aside the award there, no, like it has created a situation where subsequent to or during the pendency of the arbitration, they have executed a sale agreement in favor of a third party at the back of mine.
Therefore, the agreement is set aside.
The
entire agreement
in respect of that, there is a suit pending where they are taking a contention that, like in view of this setting aside of the award, that agreement is valid.
So that you'll have to only show. We don't know what they're saying, but the reasoning is.
So I understand. In fact, I filed an amendment petition. Amendment petition was rejected.
Let them challenge the agreement and come, Your Lordship.
Why? The agreement has been set aside. Let's see the reasoning in point 2. What is it? In the judgment which is in the appeal, point 2 is whether the agreement is against public policy.
Right, Millard. There is a finding. However, it goes ahead and then
let's see the
finding.
Let's see the finding.
The reasoning, there are 3 aspects the trial court has considered. One is the limitation as to whether 34 petition can be maintainable. That goes till 50 in page 53. Lordship would get the findings of the trial court as far as point number 2 is concerned from 53. Point 2 and point 2, 3 and 4. These are 3 points taken together for common consideration to avoid repetition. It is not in dispute that the plaintiff and the defendant have entered into a management development agreement dated so and so in respect of land bearing so and so for the purpose of formation of comprehensive layout after getting land was denotified from acquisition. I'll just skip this portion. This was briefly the background of the case is, Millards. There was a management development agreement executed between 2 parties where the property was already under acquisition by the BD. He has undertaken to initiate the process for denotification and all. The Lordship would get, these are admitted facts. Your Lordship may kindly turn to page number,
yes.
Page 56.
Yes.
Para 28.
Para 28.
20. The counsel for the plaintiff also. Plaintiff is the respondent herein who challenged the arbitral award before the trial court under 34. The counsel for the plaintiff also submits that as on the date of referring of the matter to the arbitration proceedings, the subject matter of the dispute was not capable of settlement by the arbitrator. See, it just goes on. The next para, it is further argued that as on the next para, it is further argued that on the date of execution of the agreement, the lands in dispute were already acquired by BDA and West with it. Any agreement during the acquisition proceedings is illegal, unenforceable, and it is against public policy. It just refers to case laws in this regard and repeatedly says that the agreement is invalid and unenforceable. As such, the arbitrator ought not to have gone into the question of whether readiness, willingness, any aspects or any terms, whether the party has fulfilled or otherwise. There is no arbitrable dispute. As such, like the arbitration award shall not sustain.
No, it doesn't seem to. It says the award is against public policy.
That's general. I see. It says the agreement is against public policy.
And therefore, the award is against public policy.
Therefore, no, I see. He ought not to have gone into the question of readiness or willingness or obligations of either of the parties in the arbitral proceedings.
What are you saying then? According to you, the agreement is legal and binding.
As far as the annulment of the agreement should stay. The arbitrator
are you contesting the finding that this is against the agreement was against public policy and was unenforceable?
I concede that this agreement is invalid and unenforceable. I am not quarreling on that.
Then what is wrong
but
with
ultimately,
then how will the award
set aside?
Then how will the award stay?
Ultimately, the final award is for annulment. The arbitrator.
But on a different ground. But on a different ground.
On a different ground.
So, an annulment is on a different ground. Here, the court comes to the conclusion that the agreement is invalid, which you agree.
Yes,
ma'am. The logical sequitur to that is that even the arbitration agreement is invalid. Then how will your award stay?
The arbitrator's final award is for annulment. That is where the
We followed your point that it is against annulment. We're only asking you, is the finding of the learned commercial court or learned district court that this agreement is unenforceable? You agree with that view?
Yes.
So if the agreement is against public policy and is unenforceable, then how will the award on any other ground sustain?
Ultimately, the award is, has
but on a different ground, no?
I understand.
And today an arbitral tribunal may come to the conclusion, no, he is in breach of the agreement and therefore it should be annulled. The court comes to the conclusion that this agreement itself is unenforceable. You say, yes, it is unenforceable, but the award should sustain. So you please tell us, how will the award sustain when you yourself are saying that the agreement is not sustainable?
Yes, he has given a conclusion where on the basis of this management development agreement, he has executed a sale agreement in respect of the NDA property.
No, please don't go in reverse engine by finding out what he is doing and therefore what is right or wrong. Let us go the forward way. You've challenged the finding of the commercial of the district court that this award is setting aside the award under section 34 on the ground that the agreement is unenforceable. Now you start by saying, is the finding incorrect of the learned saying? You say it's correct.
Finding is incorrect. Question is,
finding is correct, not correct.
Finding is incorrect.
Correct. Then in that finding, why would the award not be set aside?
If the Lordship gives a shorter possible date, we have engaged the senior counsels and services. Only a short point as far as the
just a learned counsel appearing for the appellant states that the agreement, management and The management and development agreement. No, just said the learned district court had
Your Lordship, without granting stay, the
concluded
case may
that
be
the
adjourned, Your Lordship.
management and the development agreement was invalid as it was against public policy. Full stop. Learned counsel appearing for the appellant submits that does not challenge the said finding. He submits and notwithstanding the said finding, the court could not have set aside the arbitral award since the arbitral award had declared the management and development agreement as cancelled on a different ground. Full stop. He seeks time to address submissions, further submissions in this term.
Charter possibility.
Yes, sir, put a short date on this.
September.
I'll put this on Friday. We'll be ready by Friday. Short question.
41/7. December 25.
Yes.
With respondent is the subscriber of the check, sir. But sir, the total subscription is for 1,50,00,000 lakhs, sir, which was due. We have raised the dispute for recovery of 1,25,00,000 lakhs, my lord, sir. In the meantime, there were some amounts which have not been paid by him for which he has issued the check, sir. Separate check bound cases was also initiated against him.
Yes.
My lord, sir, in the check bound proceedings, my lord, sir, my lordships may kindly peruse at page number 225, my lord. In the appeal, in the criminal appeal which has been filed by us before this court has specifically held that page number 227 is the relevant portion, paragraph number 2.
Yes.
May I read, ma'am?
Yes.
The appellant has raised disputes against the respondent in dispute number 233 to 240 of 1112 on the file of register of checks for realization of the amount, including the one payable under the 4 dishonored checks, in respect of which the complaints as above were presented, and the respondent was prosecuted for the offence punishable under section 138 of NI Act. In the said proceedings pending before the register of checks, the respondent has paid by way of demand draft rupees 36,50,000 to the appellant. The said amount covers the amount payable in respect of the dishonored checks in question. In view of the aforesaid payment and the pendency of the said dispute, it is necessary for the appellant to process. It is unnecessary for the appellants to prosecute those appeals and the same shall disposed of. However, it is made it clear that in the list between the parties which is subject matter of the dispute number 233 to 240 of 1112 shall be adjudicated and decided in accordance with law. The impugned common judgment would not stand in the way of parties seeking adjudication of the said dispute before the register of checks. Now, my lord, sir, the amount is 36,50,000. Which is the amount payable towards the check bounce cases, sir. My lord, sir, here what has happened? One fine day, forcefully signatures were obtained in the compromise petition, and the respondent number 4 filed a compromise petition before the registrar. My lord, that compromise petition was challenged by us well within 7 days, sir. That has been considered, and the compromise order has been set aside, which was been challenged by the respondents before the joint register. There also the order has been confirmed. As against this, the writ petition has been filed. In the writ petition, my lord, sir, the honorable single judge has held that once the compromise has been entered into, it closes the matter, you cannot reopen. My lords, my respectful submission is that, my lords, the compromise what we have entered into, it is only with respect to the 36 lakhs which has been payable before the payable with respect to the check amount. The total amount payable by the respondent is, as on the date of when you raise the dispute, is 1 crore 25 lakhs. 36 lakhs was only adjusted towards the check amount. But with respect to the remaining amount is that Malats, we are contesting the matter. We have, well within time, we have filed the application for recall of the compromise petition that has been considered. But the Honorable National Judge has said that it is only, since it is pertaining to the entire amount, he cannot reopen the compromise. We cannot reopen the compromise petition. That's the order. The relevant portion of the order is at Malats at page number 26, in page number 26, paragraph number 13, Malats.
So what is your genesis of 1 crore 25 lakhs?
Malats?
Why do you say that 1 crore 25 lakhs?
Yes, he has subscribed for 8 checks, sir. Each check pertaining to rupees 25 lakhs, Malats.
And your compromise is regarding how many checks?
4 checks. 4 checks amounting to rupees 36 lakh 50,000.
No, chits. Yes, according to you, is subscribed to 8 chits.
8 checks, sir. Well, all the 8 cases were going together, Malats. The case numbers are 230 to 241.
Yes.
All the 8 cases were jointly going together, and compromise has been, the application was filed with respect to all the cases. Annexure R1, page 222 is the application filed by Malats.
Let's see the order of 29 January 2016.
29 January 2016.
That would record your compromise.
Please, Malats.
Or the joint memo. Let us see a joint memo.
Joint memo, it is at Malats, sir.
Page 165.
165.
It's recorded in the order sheet, sir.
Translated copies of 165. The petitioner and the respondents have submitted the joint memo and mutually agreed to settle the outstanding amount due to the petitioner in the court through a single payment through DD and have signed the joint memo. The petitioner has agreed to sign the joint memo that has agreed to dismiss the pending case against the respondent by receiving 36,50,000. The petitioner and the respondents 1 and 2 have appeared and made their statements. The petitioner has agreed to this and the respondents have received the 36,50,000 while DD dated. So in this case, since the respondent have agreed to withdraw all the cases filed against them.
So you agreed to withdraw all cases filed against in various courts.
Malats, sir, my application.
And it is concluded not appropriate to proceed with the case and dismiss cases number 2.
Prior to this itself, Malats, the order before this Amba court was passed in criminal appeal. Prior to this order.
No, wherever it will be pending somewhere. All your cases are withdrawn. And these are particularly cases number 233 to 240.
Please, Malats, sir.
If this case doesn't survive, will you or any? If 233 to 240 do not survive, then
the same cases, Malats, my application at page number 222 may kindly be seen, Malats.
220?
222. This is within 7 days I filed the application. For the reasons stated in the accompanying affidavit, this Amba Court authority may recall the compromise memo filed on 29/1/2016, which is unfair, and the same was done by bringing muzzlemen and due to threat. The disputant was forced to sign the papers in the interest of justice and equity. In paragraph number 2 of my affidavit at page number 223, Malats, I submit that I have demanded the opponents to pay the outstanding check amount on several occasions. After several demands, the appointed number 1 on 15/10.
No, but did you tender your money? Did you tender back your 36 lakhs?
In the check, with respect to those check bounce cases, they have paid the money.
So no, will you give that 36 lakhs back? If you say your compromise was effected and by coercion, first thing you have to do is to go and say, please take the.
No, in 138 matter, it has been specifically stated that that has been adjusted towards the check amount.
You can't modify this as
That has been
compromise
adjusted.
statement in this manner.
No, my lord, sir, my lordships may kindly see once again the order passed in the criminal appeal, my lords, which is at page number 225. The said amount at page number 228, the said amount covers the amount payable in respect of the dishonored checks in question.
Yeah, of course it covers that amount, but it also covers more than, it doesn't say that this is only those and the others are still live.
But even in the last paragraph also, it has been stated that the dispute, whatever the pending before the parties, that will go on with respect to the remaining amount.
This order is passed on which date?
It is passed on, my lords, 9th February 2016. My lords.
And your compromise is?
Compromise was entered on, my lords, 29/1/2016. After this was clarified. This was clarified in the criminal appeal. This compromise, what has been entered, that has been clarified in the criminal appeal.
Numbers. All right. Yes. Will be defended by those private parties. Nobody's
Private
appearing for them.
parties. I appear for the authority who's passed the order, Registrar of Chit Funds. Contesting parties, respond number 1.
What about respondent 1?
Respondent number 1, my lords.
Shyam Shiv Prakash.
Somebody appearing for him. And then appears for respondent number 1 and in interest of justice re-notify.
September. December 26.
Lords, the learned my case is currently held up in court hall, another court hall, my lords.
Last occasion, my lord, the party
person had made submission.
Submission stating that the state authorities must upload the data of the students who have dropped out and the students who have been brought to the mainstream. They are willing to upload. That is the only concern she expressed.
No, she said 5/7. Mr. Farindra was to address and say they are included. That's all that was there.
The data we will upload, my lord. There is a series of program which is an ongoing process, my lord. Every year we collect the data, my lord. For the last 3 years, in fact, I have collected the data of the students who have been identified and brought to the mainstream. And we are willing to upload it, my lord, for the purpose of transparency and information in the official website. We are willing to upload that information. That is a grievance, my lord, that these data are not available.
No, that is only one.
Please.
It's only one of our concerns. The other concerns as well. We'll put it next week.
Please, my lords.
A request for adjournment is made on behalf of the learned amicus curiae who's been held up in another court. List.
6th August. Number 27.
And for the respondent number 7 this case.
Who's for the petitioner?
Mr. M.R. Vijay Kumar.
Moving for the respondent number 7, my lord.
Another prayers for the petitioner list.
11th November is number 28.
Not there is that was the PowerPoint may not run a lot order with the left-hand lot to file statements and applications, not a
Take some time, my lord.
It's a 2024 matter, my lords. On earlier 2 occasions, it's gone out. And there is a very limited question. It is a saved application. Revenue NOC by the Deputy Commissioner has given. And Forest NOC was also given earlier to 12/8/2016. And the matter ought to have been placed before the state government, whereas it was placed before the task force committee, and this honorable court was pleased to.
Learned Counsel of the Learned AGA seeks further time to obtain instructions. Final opportunity is granted to do so.
A short week's time or 10 days time, my family.
Just give a list.
24 September.
In the August month, my lords.
August is really fast.
Number 29. Working plan, my lord, is under progress. Is regarding that working plan, my lord, is still under progress, my lord. We might require some time in this matter.
How much time would you want?
Any date after 4 weeks, my lord, because we have to approach thereafter the MOEF, my lord.
Yes.
My lord, as on today, my lord, there is an interim order in operation, my lord. We have also gone on record stating that we will not carry out any activity with prohibition, my lord. We are bound to that.
Lord, may make one submission. On 15/6/26, my lord, the Honorable Court was pleased to pass an order that, my lord, the proposal has been sent to the MOF. My lord, my understanding is that, my lord, I just verified it has not been sent at all. So that has to be clarified. It would be sent, my lord. That should be clarified.
Lords, may I make a submission, Lords?
I have an interim order.
No, Lords. Lords, there is an allowance of work that's been permitted by this court, my lords, on no merits whatsoever, my lords. My lords, if I may be allowed to make a submission, my lords.
One second, this is an order now?
My lords, order dated 3rd of March, my lords.
15th June, my lord.
15/6/26.
No, but we've also recorded, if you see the order of 13 January. We've recorded your statement.
The interim order was granted based on a statement, my lord, initially. That came to be modified subsequently because we moved.
That's right. So there is a
clarity, my lord. The statement that they have made is that there is no proposal pending.
That's right. That's what they said. State said no proposal is received regarding the project in question.
That is the position today, my lord.
That is the position today, my lord, but the submission was recorded that it has been sent, therefore
My lords, I have documents to prove that the proposal was sent. It was rejected and they were re-asked to apply for the proposal again, my lords.
That submission I made on the last occasion, that they have returned the submission, so the revised proposal will be sent.
My lords,
It has not been sent.
my lords, may I, lords?
it's all right, my lord. Let him finish. my
Shanti
lord.
Bhushan, then the DSP states that the order dated 15 June 2026 records the submission of the, points out that the order records the submission of the learned additional government advocate that a proposal has been sent to Ministry of Environment and Forest seeking permission for carrying out non-forest activities. He states that no such proposal has been sent or received by the ministry. The learned AGA submits also concedes that the proposal has not been sent as yet. And his statement made on 15/6/2026 was not accurate.
My lords, on 3rd, my lords, if I may read order of my lords dated 3rd of March. Lords, learned Advocate General appearing for the state submits that all works at the site are stopped pursuant to the interim order granted on 13/1/2026. My lords, in their wisdom, granted me a stay on all works. Now, my lords, submission is that all works are stopped pursuant to the interim order, my lords. My lords, the infirmity here is that there was no permission. So at the pretext, there was no permission. They could not have initiated the work at all.
No, non-forest they could not have. Forest, for non-forest purpose they haven't, but they're saying there is some work.
My lords,
which
there
they
is
can
no,
carry out as a part of the forest.
the second infirmity with the my lord's order is, my lords, that there is no
very clear in.
there is no distinction that can be created. The allowance and the budget is a wrong linguistic term, my lords. These are funds that are allotted. The funds are allotted on challenge based, my lords. My lords, that essentially means if there was any other project that had permission, if there was any other project by any other state, they would be entitled to these funds. Submission that these are budgets is an erroneous submission, my lords. Now, second, my lords, second para of the order, my lords. Well, I could, if I may.
Yes.
In the aforesaid circumstances, we consider it apposite to modify the interim order to permit certain developments. My lords, it is one to stay the works, my lords. But it's entirely different, my lords, to allow a work, my lords. This order essentially creates a permissibility for the state to carry out works for which they have no permission, my lords. My lords, there is a statutory mandate. My lords, if I may take my lords to...
If you see paragraph 1, they say there's some works which would not require diversion of forest land.
There is no distinction, my lords. The permission for the works or for the DPR should have been sought on the entire project. It cannot be that an order allows construction of an entrance plaza and another order allows, it cannot be, my lords. The severability cannot be.
They have also argued that there are a large number of otherwise visitors there and they can use the facilities. So in either event, even if the project does not go through,
my lords, it's a forest area.
That, as far
There
as
is a
facilities are
statutory
concerned,
mandate.
they can do that.
My lords, if my lords may peruse page 77 of the objections filed, my lords. My lords, my proposition is that the permissibility of work by this order, my lords, has rendered my entire cause before my lords futile. That's my contention, if my lords may consider my submission. Page 77, my lords.
Let's take down this. The learned AGA seeks further adjournment. States that the working plans are yet to be submitted. That is request list. Listed on how much time do you?
After 4 weeks.
Put it up.
My lords, the plan and the project cannot stand muster of basic judicial review, my lords.
Okay.
If given audience, I shall establish, my lords.
3rd September. Number 30.
My lords, meantime, my lords, there is no monitoring that's happening. I have my lords, I have photographs of trees and non-forest activities being carried out at the site.
Lord, I have filed an affidavit along with them the photographs of the present status, my lord. And we will produce after completion of the work the photographs post completion of the work. Also, we have undertaken to produce before the court.
My lords, on the affidavit, my lords.
It's filed on 24th March.
My lords, on
hear this petition piecemeal.
My lords, on the affidavit, my lords. My lords, there is a precedent of this honorable court of the same bench, my lords. that declaration of deemed forest, the affidavit is filed before the Honorable Supreme Court, my lords. Any diversions, the permission and the leave has to be sought from Honorable Supreme Court, my lords.
There's no difficulty on that.
I shall produce that as well in the,
All.
if, my lords, if
Hear your
an
petition.
audit of work as to what,
We will
if-
hear your petition when we take it up. We are just adjourning. Interim orders, we've heard you on interim orders before. We've passed interim.
no, my lords, I was not heard on my interim order, my lords.
No. Call the next item.
My lords, may have it, please.
I appear for the petition. 30 and 34 are identical. In pursuance of the order dated 16/10/25, we have filed our written submissions. I may be permitted to file, my lord, the revised written submission. It is ready. I'll file it tomorrow, my lord. Your last may kindly have it day after tomorrow, along with the citation. Because in the earlier submission, I have not enclosed citations.
Good day.
I may be permitted to file revised.
Learned counsel appearing for the petitioner seeks to file revised written submissions. Let the same be filed within the period of 1 week from today. List. This is after the 30 and 34.
10th of August. December 31.
So this matter pertains to levy of environment compensation,
Yes.
wherein your lordship pursuant to Delhi Supreme Court judgment had granted a stay.
Yes.
May I be please permitted to place on record the clarification order issued in the same matter, your lordship, by Supreme Court? Page number 3, your lordship. They have noted that the above direction should not be understood to mean that the regulators, being the Pollution Control Board, cannot proceed to impose and collect the compensatory environment damage in the absence of subordinate legislation.
Yes. Who's appearing for the
Mr. Angad Kamath.
Only coercive steps have been stopped. No?
Please, Your Lordship. So the enforcement of the environment compensation has also been stopped through the interim order, Your Lordship.
None appears for the petitioner. Learned Counsel appearing for Karnataka State Pollution Board is referred to and dated 21/5/2026, passed by the Supreme Court clarifying the directions issued in Delhi Pollution Control Committee versus Lodi Property Co. Limited, 2025 SCC online SC 1601. Full stop. The said order is clarified. As 21/5/2026, passed in civil appeal number 757-760/2013, caption BPCC versus Union of India through Secretary. The said order clarifies the directions issued by the Supreme Court in Delhi Pollution Control Committee versus Lodi Property Co. Limited. The Supreme Court had referred to the directions in paragraph 39, bracket C of the said decision and then clarified as under. To say it was. This court had passed an interim order on dated 14/11/2025, directing that no coercive steps be taken for recovery of the environmental compensation on the basis of the directions issued on paragraph 39, bracket C of Delhi Pollution Control Committee versus Lodi Property Co. Limited Sutra. Since the said directions have been since clarified, the interim order passed on 14/11/2025 stands vacated. List for further consideration on that. Let's copy this.
11 November. Number 32.
The petitioner, being aggrieved by Lord Annexure A, a work order, Lord, petitioners are before this court. Lord, the grievance of the petitioners are, Lord, that while the work order, a Rangamantra, Lord, open theatre is not directed to be put up by leaving, Lord, about 16 feet into 300 feet, Lord, between the compound wall, Lord, and that open theatre. Initially, Lord, earlier, by way of a writ petition, not the very same petitioners, except not the petition number 3, had approached not this honorable court, not the public interest litigation came to be allowed. Page number 40, not Annexure C. Just to protect, Lord, the government field, wherein, Lord, several, Lord, government institutions running, Lord, from Anganwadi, Lord, to colleges are there. About 36 Kunta, Lord, is the only place available for them to play. Page 40, Lord, is the order. But the operative portion, Lord, the relevant portion is at page 46, Lord, para number 3 onwards. May I just read?
Yes.
Page 46, para 3. The subject land bin has been depicted in Annexure A4, a perusal of which shows that an endeavor has been made to carve out a road within the and across the property of the composite college and school. The state government has taken the stand that no permission was granted for the construction of the road within the property of the composite government pre-university college or for the construction of a wall for any purpose whatsoever. There is no challenge to the ownership and possession of the composite pre-university college. By recording this, my lord, the writ petition came to be allowed. My lord, the relevant portion, paragraph number 5. My lord. In these circumstances, writ petition is allowed. Respondent number 9, the Deputy Commissioner Ramnagara Taluk District, Ramnagara, is directed to take immediate and necessary steps for the removal of wall within the property of the composite pre-university college, Biddi, needful to be done within 4 weeks from today. Thereafter, my lord, a compound wall, my lord, was annexed. By breaking open the compound wall, my lord, the residents of, my lord, a nearby colony, they were making way, my lord, inside the, my lord, school field. Now, my lord, to make it as a final thing, now this work order is issued by leaving, my lord, 16 feet into 300 feet, my lord, between, my lord, the compound wall, my lord, and the Rangamandira. There is already a Rangamandira, my lord, inside the premises. A second, my lord, open theatre is being constructed just to leave this space, my lord, as a, my lord, access road to the nearby colony, my lord. One of, my lord, the resident of a colony, he is elected, my lord, as the corporator, my lord, of the 10th respondent, my lord, corporation. So he is behind all this. And videograph, my lord, is also produced, wherein, my lord, the member of, my lord, the legislative assembly, he is openly saying, my lord, that if we do like this, no court will stop us from doing this. And one of the officials, my lord, he has also, my lord, a recorded conversation, typed copy, my lord, is produced by me. My lord, I'll just show it. Annex G, my lord, page 66. He is also clearly saying, my lord, that they are trying to leave open, my lord, a, my lord, access road to the nearby, my lord, the colony residents. In that view of the matter, my lord, the petitioner, my lord, are again, my lord, constrained to approach this.
Instructions this morning, if my lord could grant me 2 weeks, my lord, I'll file this date.
Let's see the map.
Please, Annex K, my lord, Annex page 73. There are access roads, my lord, from either direction. This black portion, my lord, this is where, my lord, they are trying to put up the control.
Where you see it,
Page 73.
75C.
Lord, Annex K, my lord.
Yes.
Please, this portion, my lord, this black mark portion. That is the compound wall. By leaving about 16 feet into 300 feet, my lord, they are constructing.
No, so the school is there. There is a gate open for the passage open for the school.
Yeah, yeah, that gate is open, my lord. That is only, my lord, for the school and college purpose.
That's
Not for the nearby residents. It is fully covered by the compound wall. This gate is open, my lord, for the school purpose only, my lord, school and college.
There are two schools. One is a government school. One is
No, that is this is, my lord, separate. This is not
Basaveshwara school.
by way of a compound wall. This is separated. That is Basaveshwara school, not that is another school. That's a private school.
So this path is being made,
Inside the government school.
and it is leading to the.
That is leading to the gate.
My lord, just by way of a preliminary glance, my lord. My lord, the photographs. Let's show this to us. The open theater is in the second page, my lord.
Yes.
The open theater,
Yes.
my lord, is in the second page of the photographs that I have
Yes.
produced before my lord. It's for the children's cultural activities, my lord. I'll file my statement, my lord. I've just received it.
His case is that once you open this gate, this road, it's a thoroughfare between the Bidadi main road, railway station, and the crossroad behind.
My lord, I'll justify that.
Learned AG 6. Time to file as statement of objections. You know, in your map, where is this open theta?
There is already one it is not to the other side. One that is being constructed here.
No, this one which they have said is where in your map where?
Annexure K, my lord. The newly
K, where does it reflect this open
newly
theta?
constructed, my lord, is this portion, my lord, this black portion.
No, that's only a road access.
No, there, my lord, they are constructing now.
You have to show.
Next to the compound wall.
I'll give him a copy.
Yes, my lord, I'll file my objections on
This.
Second November.
Please.
Resolution.
So, list number 2, seal number 30.
Yes, I'm the petition. I am submitting environmental petition.
You are in which petition?
I am going with that.
No, which petition are you appearing in? Which is the petition are you appearing in?
Serial number 30, I believe, my lords. It says Mahendra Kumar Mitra. He was party in person previously, my lords. I think he's filed.
We are taking up 30.3 WP 25515.
Yes, madam.
Yes.
My lords, yesterday, when the matter stood over, my lords, I was seeking to refer to Annexure J, page 183, report of Justice Nagmohan Das Commission, submitted on 1st August 2025. To show that the findings, there are two reports which do not gel with each other. I'll just point out one sentence, my lords, from page 191. Two sentences, the three-line paragraph, my lords. Should my lords have paid? After the tabular column, this is what the finding, my lords, insofar the progress of the scheduled caste is concerned. The performance of scheduled caste in the field of literacy is excellent. Out of 101 castes, 83 have a literary rate higher than 80%. That is
the literacy rate of 83 KAS is higher than the state level average literacy rate. To say, my lords, after these many years, there is no progress. This falsifies the claim. Then, my lords, the report also refers to the various employment details that I have placed before, my lords, the 31/3/2023 figures given by the government department itself. Therefore, I would not like to trouble my lords with all those things. Now, my lords,
Yes. Yes.
my lords, I referred to Lordship Justice Ashok Bhushan's view in Jayesh Lakshman Rao Patil, particularly with reference to, my lords, the adequacy of representation and all that. A few more paragraphs from that judgment, my lords. If my lords would kindly take volume 2 at the 844 page. That is where the judgment of the Supreme Court in Jayesh Lakshman Rao Patil commences. Then was if 50% ceiling is breached, what would be the consequence? Is very graphically dealt with. Before I go to Lordship Justice Ashok Bhushan's view, concurring view of Lordship Justice Ravindra Bhatt, it is at page 919, para 33 minutes.
Yes.
Upon examination of the issue from this perspective, the ceiling of 50% with the extraordinary circumstances exception is the just balance, what is termed as Goldilocks solution. The solution containing the right balance that allows the state sufficient latitude to ensure meaningful affirmative action to those who deserve it, and at the same time ensures that essential content of equality and its injunction not to discriminate on the various prescribed grounds, caste, religion, sex, place of residence is retained. This court in M. Nagaraj versus Union of India observed that a numerical benchmark is the surest immunity against charges of discrimination. To dilute the 50% benchmark further would be to effectively destroy the guarantee of equality, especially the right not to be discriminated against on the grounds of caste. Footnote, my lords, may kind of footnote 45 there. The what is Goldilocks solution is, the difficulty then is finding the Goldilocks solution, not too large, not too small, but just right. That is how 50% ceiling is described. Then, my lords, at para 34, next page, the lordship says that there is no, rejects the argument seeking reference of reconsideration of Indrasan. Then, my lords, to page para 384, 386, my lords, at page 1060. Rest of the paragraphs I have taken, my lords, in between there. 386, my lords, page 1060.
Yes. Yes.
The judgment of Indira Sani has been followed by this court in a number of cases, including at least the following 4 constitution benches: Postgraduate Institute of Medical Education, M. Nagaraj, K. Krishnamurthy, which judgment, though was considering reservation under 243 and 247, has applied 50% ceiling as laid down in Balaji. That is not even where proportional representation is applicable, 50% ceiling is sacrosanct. The Constitution Bench judgment of this court in Cheprola Leela Prasad Rao reiterated the principle as referred and reiterated that outer limit is 50% as specified in Indira Sani's case. This was the case of teachers in scheduled areas where 100% reservation was provided. Then moving on, my lords, para 391 at page 1061, Dr. Ambedkar's speech is reproduced in the Constituent Assembly. If the honorable members will bear these facts in mind, the 3 principles we have to reconcile, they will see that no better formula could be produced than the one that is embodied in clause 3 of Article 10 of the Constitution. They will find that the view of those who believe and hold that there should be equality of opportunity has been embodied in clause 1 of Article 10. It is a generic principle. At the same time, as I said, we have to reconcile this formula with the demands made by certain communities that the administration, which has now, for historical reasons, been controlled by one community or a few communities, that situation should disappear, and the others also must have an opportunity of getting into the public services. Supposing, for instance, we were to concede in full the demand of those communities who have not been so far employed in the public services to the fullest extent, what would really happen is we shall be completely destroying the first proposition upon which we are all agreed, namely that there should be inequality of opportunity. Let me give an illustration. Supposing, for instance, reservations were made for a community or a collection of communities, the total of which came to something like 70% of the total posts under the state, and only 30% are retained as the unreserved. Could anybody say that the reservation of 30% as open to general competition would be satisfactory from the point of view of giving effect to the first principle, namely that there shall be equality of opportunity? It cannot be in my judgment. Therefore, the seats to be reserved, if the reservation is to be consistent with clause 1 of Article 10, must be confined to a minorities of seats. It is then only that first principle could find its place and the Constitution in the Constitution and effective in operation. The above views of Dr. Ambedkar expressed in the Constituent Assembly for the balancing draft Article 10.1 and 10.3 equivalent to Article 16 and 16.4 have been referred to and relied on by this court in Indira Sani as well as in other cases. Remember paragraph 397 at page 1063. The 50% rule spoken of in Balaji and affirmed in Indira Sani is to fulfill the objective of equality as engrammed in Article 14, of which Articles 15 and 16 are facets. Indira Gandhi itself gives answer to the question. Rest of it, they refer to para 807, held that what is more reasonable than to say that reservation at class 4 shall not exceed 50% of the appointment. 50% has been found said to be reasonable and is to attain the objective of equality. Para 807 is extracted. Then, my lords, 398. In para 808, BP Jivan Reddy referred to speech of Ambedkar, where he said reservation should be confined to a minority of seats. The expression minority, when translated into figure, the expression less than 50% comes into operation. To change, this is very crucial, notice, para 399, where the Supreme Court says to exceed the 50%, it will be replacing society based on equality into a society based on caste. To change the 50% limit is to have a society which is not founded on equality, but based on caste rule. Democracy is an essential feature of our constitution and part of our basic structure. If the reservation goes above 50% limit, which is reasonable, it will be a slippery slope. The political pressure will make it hardly to reduce the same. Thus, the answer to the question posed is that the percentage of 50% has been arrived at on the principle of reasonability and achieves equality as enshrined by Article 14, of which Article 15 and 16 are facets. Earlier, it was treated as an exception, but now the 16.4, 15.4, now there's a Article 15 grants general equality, 15, 16 specified fields. Then, the 406, at page 1066, Lordship Justice Ravindran Chiu and Ashok Kumar Thakur is reiterated. Of course, my lords, after saying all this, Supreme Court is yet to fix a time frame. That is, my lords, for whatever reason. Because in more than once, number of learned judges have felt that there should be a time frame, but that is elusive as yet. 406, my lords. That is 1066. We recall the observation made by R.V. Ravindran J. in Ashok Kumar Thakur, wherein his lordship held that any provision of reservation is a temporary crutch. Such crutch by unnecessarily prolonged use should not become a permanent liability. In words of Ravindran J., caste has divided this country for ages. It has hampered its growth. To have a casteless society will be a realization of a noble dream. To start with, the effect of reservation may appear to perpetuate caste. The immediate effect of caste-based reservation has been rather unfortunate. In the pre-reservation era, people wanted to get rid of the backward tag, either social or economical. But post-reservation, there is a tendency even among those who are considered as forward to seek the backward tag in the hope of enjoying the benefits of reservation. When more and more people aspire for backwardness instead of forwardness, the country itself stagnates. Be that as it may, reservation as an affirmative action is required only for a limited period to bring forward the society and the social and educationally backward classes by giving them a gentle supportive push. But if there is no review after a reasonable period and if reservation is continued, the country will become a caste-divided society permanently. Instead of developing a united society with diversity, we will end up as a fractured society forever, suspicious of each other. While affirmative discrimination is a road to equality, care should be taken that the road does not become a rut in which the vehicle of progress gets entrenched and stuck. Any provision for reservation is a temporary crutch. Such crutch by unnecessary prolonged should not become a permanent liability. It is significant that Constitution does not specifically prescribe a casteless society nor tries to abolish caste, but by barring discrimination in the name of caste and by providing for affirmative action, the Constitution seeks to remove the difference in status as basis of caste. When the differences in status among the castes are removed, all castes will become equal. That will be a beginning of casteless egalitarian society. Now, the government comes and says that after 73 years of reservation, we have to increase the percentage of reservation. That is something, my lords, which on the face of it runs counter to this view. Then, my lords, para 508 at 1102. What are the parameters of judicial review in these matters? Because one of the contentions raised by the state is that it is a policy matter, it is a legislative policy, and this court has to keep its hands off. But Indira Sani has referred to the judgment of this court in barium chemicals for the scope and reach of judicial scrutiny. We need to refer the test enunciated in barium chemicals. The Constitution bench in barium chemicals had occasion to consider the expression, if in the opinion of the central government occurring in section 237 of the Companies Act. Hidayatullah Jai laid down that No doubt, the formation of opinion is subjective, but the existence of circumstances relevant to the inference as the sine qua non for action must be demonstrable. The following observations were made in para 27. No doubt the formation of opinion is subjective, but the existence of circumstances relevant to the inference as the sine qua non for action must be demonstrable. If the action is questioned on the ground that no circumstances leading to an inference of the kind contemplated by the section exists, the action might be exposed to interferences unless the existence of circumstances is made out. As my brother Shirath has put it trenchantly, it is not reasonable to say that the clause permitted government to say that it has formed the opinion on circumstances which it thinks exist. Between things exist and exist, there is a sea of difference. Since the existence of circumstances is a condition fundamental to the making of an opinion, the existence of circumstances, if questioned, has to be proved at least prima facie. Sheila J, with whom Hidayatullah J has agreed, in para 63 laid down the following. Therefore, the words reason to believe or in the opinion of do not always lead to the construction that the process of emphasizing reason to believe or the opinion is an altogether subjective process, not lending itself even to a limited scrutiny by the court, that such a reason to believe or opinion was not formed on relevant facts or within the limits, or as Lord Radcliffe and Lord Reid called, the restraints of the statute as an alternative safeguard to rules of natural justice, where the function is administrative. Then, my lords, may kindly come to para 513, my lords. The grant of reservation under Article 15.4 or 16.4, either by an executive order or by a state or legislature measures or constitutional measures which are contemplated to fulfill the principle of equality. The measures taken under 15.4 and 16.4 thus can be examined as to whether they violate any constitutional principle, whether they are in conformity with the rights under Article 14, 15, and 16 of the Constitution. The scrutiny of measures taken by the state, either executive or legislative, thus has to pass test of constitutional scrutiny. It is true that the court has to look into the report of the commission or commission with deference, but scrutiny to the extent as to whether any constitutional principle has been violated or any constitutional requirements has not been taken into consideration is fully permissible. As laid down in V. Balram's case, the judicial scrutiny is also permissible as to whether from the material collected by the commission or committee, the conclusion on which the commission has arrived at is permissible or reasonable. Therefore, not only the constitutional test of not breaching 14, 15, 16, but also whether the material was such that a reasonable, rational mind would have come to the conclusion that the state has drawn. Then, my lords, yesterday I have taken, my lords, through the adequacy question, but only that is, my lords, question number 12 at page 1104. Only one paragraph, my lords, at page 565 at 1121, where the Supreme Court said that after 70 years of independence, every segment of the society is presumed to have marched ahead. If anything contrary has to be done, it has to be demonstrated. We have completed more than 70 years of independence. All governments have been making efforts and taking measures for overall development of all classes and communities. There is a presumption, unless rebutted, that all communities and castes have marched towards advancement. This quote, there, my lords, it is Ram Singh. This is because one may legitimately presume progressive advancement of all citizens on every front, social, economic, and educational. Any other view would amount to retrograde governance. Yet, surprisingly, the facts stare at us indicate a governmental affirmation of such negative governance, inasmuch as a decade-old decisions not to treat the Jats as backward arrive at on due consideration of the existing ground realities have been reopened in spite of perceptible all-round development of the nation. This is the basic fallacy inherent in the impugned governmental decision that has been challenged in the present proceedings. We also endorse the opinion of Brother S. Ravindra Bhatt on affirmative actions and giving of more and more incentives related to the Constitution, which undoubtedly is the obligation. We are constrained to observe that when more people aspire for backwardness instead of forwardness, the country itself stagnates and situation is not in accordance with constitutional objectives. Then one of the conclusions of this one, they are at paragraph 688, page 1166, my lord. I take my lords only to conclusions 1 to 9. Conclusions 1 to 13, which should be relevant to this to our present issue of reservation. From our foregoing discussion and finding, we arrive at the following conclusions. The greatest common measure of agreement is 6 separate judgments delivered in Indrasani is reservation under Article 16(4) should not exceed 50%. For exceeding reservation beyond 50%, the extraordinary circumstances as indicated in para 810 of BPG1DJ should exist, for which extreme caution is to be exercised. The 50% rule spoken in Balaji and affirmed in Indrasani is to fulfill the objective of equality as engrafted in Article 14, of which Articles 15 and 16 are facets. 50% is reasonable and it is to attain the object of equality. To change the 50% limit is to have a society which is not founded on equality but based on caste rule. We are of the considered opinion that the cap on percentage of reservation as has been laid down by the Constitution Bench in Indrasani is with the object of striking a balance between the rights under Article 15(1) and 15(4) as well as 16(1) and 16(4). The cap on percentage is to achieve principle of equality with the object to strike a balance which cannot be said to be arbitrary and unreasonable. Providing reservation for advancement of any specifically education backward and public service is not the only means or method for improving the welfare of backward class. The state ought to bring other measures, including providing educational facilities to the members of backward class free of cost, giving concession in fee, providing opportunities for skill development to enable the candidates from the backward class to be self-reliant. There can be no quarrel that society changes, law changes, people change, but that does not mean that something which is good and proven to be beneficial in maintaining equality in the society should also be changed in the name of change alone. When the Constitution Bench in Indrasani held that 50% is upper limit of the reservation under Article 16(4), it is the law which is binding under Article 141 to be implemented. You find Constitution judgment is also fully applicable in reference to 15(4) and the Constitution. Then Lord's TMAPI is distinguished, where it said that the setting aside of 50% of the 11-judge bench in TMF as was laid down in Stephen case is 50% ceiling in admission in aided minority institutions and has no bearing on the principle of 50% ceiling laid down in Indrasani in respect of reservation. Judgment of TMFI was in reference to rights of minority under Article 30 and is not relevant for reservation under Article 16(4) and 15(4). The Constitution 81st Amendment Act, by which Clause 4B was inserted in Article 16, makes it clear that ceiling of 50% has now received constitutional recognition. Where, my lord, by that amendment, the 50% requirement was waived in respect of filling up of backlog vacancies. They are also subject to certain conditions. The fully endorses the submission of Sri that extras which indicated in para 810 of Indrasani's case were only illustrative and cannot be said to be exhaustive. We, however, do not agree with Mr. Rothi that para 810 provided only a geographical test. The use of expression on being out of the mainstream of national life is a social test which also needs to be fulfilled for a case to be covered by exception. We do not find any substance in any of the 10 grounds to refer the Indrasani for a larger bench. What was held by Constitution Bench in relevance and significance of the principal state, this is clearly binds us. The judgment has stood the test of time and has never been doubted by any judgment of this court. The Constitution Bench judgment of this court in Indrasani neither needs to be revisited nor referred to a larger bench for consideration. The Constitution of Nagaraj does not contain any ratio that ceiling of 50% may be exceeded by showing quantifiable contemporary data relating to backwardness. The Commission has completely misread the ratio of the judgment. Then what's one another argument that is no, Manors, in the Chebro Leela Prasad Rao, in volume 3, Manors, page 1173. And the judgment starts at 1173. Volume 3. The para 113 at 1266.
Yes.
Para 113.
Yes.
What is sought to be achieved by Article 14 and 16 is equality and equality of opportunity. 14 and 16. In Indira Sahni, this court emphasized that founding fathers never envisaged reservation of all seats and 50% shall be the rule. Some relaxation may become imperative, but extreme caution is to be exercised. Then, my lords, 808 and onwards it is extracted. That I skip, and my lords may kindly turn to para 117, my lords, at 1267. The question emanating in this case is how to balance the rights of scheduled castes and scheduled tribes, whether providing 100% reservation in favor of particular class is permissible. The High Court referred to Constituent Assembly debate that may be not relevant to be read. 119 M.R. Balaji, then my lords, para 121 at 1269. In M. Nagaraj versus Union of India, it was held that ceiling limit of the reservation is 50%, without which the structure of equality of opportunity in Article 16 would collapse. This court held, we reiterate that ceiling limit of 50%, the concept of creamy layer, and the compelling reasons, namely backwardness, the inadequacy of representation, and overall administrative efficiency are all constitutional requirements without which the structure of equality of opportunity in Article 16 would collapse. Reliance has also been placed on Union of India versus Rakesh Kumar on behalf of the respondents, which related to Articles 243, 243, 15.4, 16.4, and Schedule 5 to the Constitution under Part 9 to extend Panchayat Raj system to scheduled areas. It was held that post of chairperson of Panchayat and scheduled tribes in the scheduled areas cannot be put into a disadvantaged position. Because of the peculiar conditions in those areas, it is permissible that chairpersons of scheduled areas should be exclusively from scheduled tribe only. It was also held that Article 243D envisages proportionate representation and is distinct and an independent constitutional basis of reservation in Panchayati Raj institution. The reservation of 243D cannot be compared with affirmative action measures under 15.4 and 16.4, where a balance is to be maintained between affirmative action measures and merits. This court pointed out through Articles 14, 15, and 16 provide for affirmative action measures. However, there is a need for periodical review, keeping in changing society. The difference between 243 and 16.4 was pointed out in Rakesh Kumar, especially on the unavailability of analogy between 16.4 and 243. We are in agreement with decision of the Bombay High Court, reported in Vinayak Rao Gangaramji Deshmukh versus P.C. Agarwal. The case that involved a fact situation where chairperson position in a panchayat was reserved in favor of scheduled caste women. In the course of upholding this reservation, it was held. Now, after the 73rd and 74th constitutional amendment, the constitution of local bodies has been granted a constitutional protection, and 243D mandates that a seat shall be reserved for scheduled castes and scheduled tribes in every panchayat under clause 4 of the said article 243, also that the office of chairpersons in the panchayats at the village or any other level shall be reserved for the scheduled caste. The scheduled caste will be in such manner that the legislature a state may by law provide. Therefore, the reservation in the local bodies like the village is not governed by Article 16.4, which speaks about the reservation of in the public employment, but a separate constitutional power directs the reservation in such local bodies. Then rest of it is only reproduction of Indira Sani. Para 122.3. It refers to, my lords, the reservation. Again, in local bodies, in the state of Jharkhand, under the Panchayat Raj Act, then, my lords, it starts like this. However, in addition to 50% reservation in favor of scheduled tribes, the state of Jharkhand is also under obligation to account for the interests of scheduled castes, etc. Then those circumstances are discussed. Therefore, it said that that would not apply for Article 16.4. Then, my lords, in K. Krishnamurti, that is referred at para 123. Yes. 123, my lords, at page 1272. This was in relation to reservation in panchayat, in local bodies in the state of Karnataka itself, where after para 66 as extracted at page 1274. This is very relevant for us because in the state of Karnataka, even in respect of local bodies, Supreme Court has held that 50% shall be the ceiling. Admittedly, this is where I'm at the middle of page 1274. After Placitum C. Members.
Yes.
Admittedly, reservations in excess of 50% do exist in some exceptional cases. There are also, my lords, exceptional cases pointed out. When it comes to domain of political representation, for instance, the legislative assemblies of the states of Arunachal Pradesh, Nagaland, Meghalaya, Mizoram, and Sikkim have reservations that are far in excess of 50% limit. However, such a position is the outcome of exceptional considerations in relation to those areas. Similarly, vertical reservation in excess of 50% are permissible in the composition of local government institutions located in the 5th schedule. In the recent decision reported in Union of India versus Racket, this court has explained why it may be necessary to provide reservations for scheduled tribes that exceed 50% of the seats in panchayats located in scheduled areas. However, such exceptional consideration cannot be invoked when we are examining the quantum of reservations in favor of backward classes for the purpose of local bodies located in general areas. In such circumstances, the vertical reservation in favor of SC, ST, OBC cannot exceed the upper limit of 50% when taken together, except where scheduled area or difficult terrains are there. The Supreme Court reiterated, even in respect of local bodies, it cannot exceed 50%. Then, my lords, they refer to Vinayak Rao Ganajay Rao, that is 124. The decision of the Bombay High Court in Vinayak Rao regarding distinction between the was affirmed. This court observed that some decisions in the past examined validity of reservation, local self-government, applying principles evolved about employment, education. It was also that for scheduled caste, scheduled on the backwards, the level playing field is sought to be created by conferring reservation benefits. In K. Krishnamurti, this court emphasized that socio-economic backwardness does not necessarily coincide with the political backwardness, which did not necessarily be emphasized in 15.4. Barriers to political participation are not of the same character as barriers that limit it to education and employment. Concerning vertical reservations, it was said that they have to be made in the upper ceiling of 50%. In so far as Karnataka is concerned, even in respect of local bodies where proportional representation is spoken of, the Supreme Court reiterated that it cannot exceed 50%. Then, my lords, the only one paragraph, that is, my lords, para 166.2 at page 1296. 1296, my lords, that is even where, when it came to scheduled tribes in scheduled areas of Andhra Pradesh. One sick question. GOM's 3 of 2000 providing for 100% reservation is not permissible under the Constitution. The outer limit is 50% as specified in Indira Swami. It was in respect of scheduled areas. What are commonly known as the company districts, they call even today locally, because it was under company rule for long years, even after the British government came. Even today, those districts are referred as company districts, mining districts, very remote districts. Para 168 is the conclusion, members. We cannot ignore the fact that a similar GO was issued by the erstwhile state of Andhra Pradesh in the year 1986, which was quashed by the state administrative tribunal, against which appeal was preferred in this court, which was dismissed as withdrawn in the year 1998. After the withdrawal of the appeal, it was expected of the erstwhile state of Andhra Pradesh not to resort to such illegality of providing 100% reservation again, but in GM 3 of 2, which was equally impermissible, even if the AP Regulation Reservation of Public Service Act would have been amended. In that event also, providing reservation beyond 50% was not permissible. It is rightly apparent by the appellant that the state may again, by way of misadventure, resort to illegal exercise as was done earlier. It was at least expected of the functionary like government to act in aforesaid manner, as they were bound by the dictum laid down by this court in Indira Sani and other decisions, holding that the limit of reservation not to exceed 50%. There was no rhyme or reason why the state government resort to it. It is unfortunately illegal exercise done in 86 was sought to be protected by yet another unconstitutional attempt by issuing GO 2000 with effect from 1986, and now after 20 years have passed, they saving the appointments already made. Here no appointment has been made under the new act as yet. Then, my lords, about the quantifiable data, the sole reliance that is placed by both Nagmohan Das Commission and also Subhash Ade report is on Ratnaprabha report. Ratnaprabha report was not only, of course, no doubt it was accepted in VK Pavitra 2 by the Supreme Court, by 2-judge bench. But subsequently, my lords, in Jarnail Singh, a 3-judge bench specifically referred to Ratnaprabha committee report and said that it is flawed and founded on wrong presumptions. There is, my lords, in Jarnail Singh, volume 4, page 1694. Relevant is at page 1733, para 63. Five more minutes, my lords. My lords should permit me.
Tomorrow. You continue tomorrow.
No, I'll conclude. No difficulty, my lords. If my lords have time, I will conclude.
No, we have time. It's up to you.
Very well.
If you want, you can continue tomorrow.
Very well.
And you'll also have to show us those judgments where the ceiling has been breached.
To my knowledge, my lords, except in the tribal area where Panchayat Raj
No,
institutions.
there are judgments.
That is RC Podial is there, my lords. That is in
Just see that
respect of,
judgment.
I'll point out that.
And then you can conclude.
Yes.
Who will be the next council?
In Janhit, my lords, I'll refer my lords to Janhit,
Yes.
where they reiterated while upholding 10% reservation for economically weaker sections. They reiterated that insofar as 15.4 and 16.4 is concerned, 50% is ceiling.
Who will be the next in the next matter?
I am
On the petitioners. There are 5 petitions. No?
That's for the petitioner and then the first petition, PI, 30 point.
One is a
PI.
yes, one is a petitioner in person. That is 30. 30.1. You are in 30.1.
Oh, 30.4 pertains to internal reservation, my lords, which has nothing to do with the 50% ceiling.
That's 30.4. We had issued a government order where in the subject minutes we had referred to the interim order passed by this in 2W. So therefore it got linked by the learned single. But it does not relate to 56%.
So we'll de-link this.
It can be de-linked. It's 30 point.
That could be de-linked, my lords, because the issue here and there are totally different.
30.2.
State, my lords, because the roster has been set aside by the KAT. Against that, they are in appeal. They are in writ petition.
So you will you'll answer this first, or you will take this first?
I am entirely at the disposal.
No, entirely you tell us how you want to.
What I would request is, please give me half a day, any day convenient to the court. Let them complete.
They will complete by tomorrow.
Please give me half a day, any day convenient to the court. I'll finish my argument.
No, we'll continue. We won't stop. You
Please.
continue. It will be continuing day to day. You finish.
Provided it starts at 2:30, I'll be very happy because it is difficult to make an impact if it is heard only at the fag end of the day.
No, don't worry.
No, for me, I'm an old man. Court should give me some. I'm not that young. So give me half a day.
Professor Young here. It's okay. But we'll give you
any day, half a day, either in the morning or in the evening.
We'll give you an hour on a continuous basis. Minimum an hour we'll give.
No, I may need half a day.
Half a day is only 2 hours.
2.5 hours I'll be having.
2 hours. So you take it over a period of 3 days. So
instead of that, in one go, I will be able to finish my arguments.
We won't be able to take up any other matter. People are also waiting for the urgent matter. So
I respectfully agree. Therefore,
have any other job to do.
No, in fact, under the rules, a parted matter is entitled to be given priority. Please give that priority to this case because of the importance of the case.
Why do you think we're hearing it day to day?
Half a day, any day convenient.
In fact, my lords have been giving due preference to this. Yesterday, my lords sat at 2:30. I never expected my matter would be taken up. Yet, my lords were kind enough to take up because to maintain the continuity and tempo.
That's why we are taking up day to day. If you wanted half a day, then
Yes.
you're bound by half a day. We'll give you half a day, no more. We'll take it up at 2:30 and you end on that day.
Day after tomorrow.
Whatever, let them finish.
Yes, but tomorrow I'll finish.
Whenever we are able to give you half a day, we'll give you half.
Great.
That's one submission.
Firstly,
So
35.4 is deleted.
30.1 was not deleted, it was
30.4.
de-linked.
D-link, sorry, D-link.
30.4 is de-linked.
De-linked.
Will be taken up separately.
Please.
We'll take up your petition. You'll get your half a day for petition and your response.
Please.
All right. Item 30.4, say the Learned Counsel for the party state. This issues involved are relating to internal reservation and therefore are not, in that sense, not connected with the and are not similar to the issues raised in WP 25515 of 2025.
There is an
According to
amendment
the
application.
the
my lord,
present
in-
petition is delinked from the
So Ashwini.
There is
matter
an
is delinked.
amendment application, my lord, in
WP 200448 of 2025. The petitioner in person was here. How long will you take?
I am appearing on behalf of
How long will you take?
my government.
How long will you take is the question.
I'm submitting written argument.
Written arguments. All right. Give a copy to them also.
Super.
That's one submission.
ಮುಗೀತು. ಇಲ್ಲ, their job is over.
That's one submission minutes. List one, cell number 39 minutes. 39.4, there is an IA. We have to notify the mining lease minutes. The prospecting license was in respect of 1,400 acres for gold minutes. But I don't know, deposits have been found only for 200 acres and IA is pending. Any day minutes, second list minutes.
Somebody took an adjournment in 39. 39 item.
It did not reach.
Yeah, no, somebody mentioned 39.
My lord, serial number 48 in list 1 is a contempt matter for a child who has been taken away and custody has not been handed over. In fact, service is complete, though it says police report not yet received. It's on record. Police report has been received.
We'll give you next week.
Can it be taken next week, my lord? It's Tuesday, Wednesday next week.
Serial number 33, Millards. The state has filed its objection. It's a matter of PIL with regard to the appointment to the consumer commissions. The state has already filed their objections, Millards. A date may be fixed for the final arguments. Kindly.
We'll give you the dates.
ನಾಲ್ಕನೇ ತಾರೀಕು ಬೇಡ.
Thank you.